Clause 7. Royalties and intellectual properties rights. We have 3 subclauses here. These are the relevant statements. For full sentences, you may refer to the PAM contract 2018. Indemnity to employer. In principles, all royalties and other sums payable in respect to the supply and the use of carrying out the works or any article, process, inventions or drawing should be deemed to have been included in the contract sum. That means at the stage of tendering, the contractor should have already aware if any part of the work will have issues with the royalties and intellectual properties rights. In the case such issue is involved, the relevant costs for the royalties and intellectual property rights should have included during the tendering process. That means this should have already been resolved at the early stage before the formation of the contract. If the contractor did not include that, it is deemed to have been included in the contract sum, and the relevant cost it will be fully on the contractor. Let's say now the contractor do not pay for the royalties or intellectual properties right. Whichever penalties, claim, damage or any relevant costs will have to be borne by the contractor. Normally, this problem will come to the employer first, and the employer can claim from the contractor. In another word, the issue related to the royalties and the intellectual properties, it is full responsibility of the contractor. The contractor should be aware of that and should theoretically have those resolved. If it is not resolved, when any claim are made against the employer, the relevant costs will be charged to the contractor. This clause is subjected to the clause 7.2, which is this one, where there are circumstances that the contractor is not liable in the case of infringement. The meaning of infringement is the actions of breaking the laws and agreement or violations in terms of the royalties and intellectual properties. Normally, when there is an infringement, the owner of the royalties or the intellectual properties have the right to claim for the loss that deems to be reasonable, and this normally will be charged to the employer. If it is full responsibility of the contractor, that means the employer has the right to charge to the contractor. There is a situation where the contractor is not liable. It is when the contractor has already informed the architect in writing that there may be infringements of the intellectual properties right. That means the contractor has already notified the relevant issue that the relevant issue needs to be resolved. However, the architect still instructs the contractors in writing to comply. That means the instructions received by the contractor is to ignore that issue. In this case, the contractor is clear from the liability as he has already informed the employer side or the architect that the relevant issue is to be resolved. However, the architect or the employer side ignore the relevant issues. So at the end of the day, when there are claims or penalty due to this infringement, the contractor is allowed to claim, and the relevant costs will be added to the contract sum. That means the employer will have to pay for that. The third one is about the government royalties. Except for those provided in the contract, the contractor should pay all the government royalties, levies, rents, and other payment in connections to the work. If the payment is to be covered by the employer, it should be clearly stated in the contract. Otherwise, the contractors will have to incorporate all those into their costs while bidding for the tender. All this need to be paid by the contractor without any adjustment in terms of the contract sum. Based on what we have understand from clause 7, probably it is easier for us to understand by looking at the flow chart here. As it was mentioned in the statement here, all the relevant costs for the usage of the royalties or intellectual properties is deemed to have been included in the contract sum. That means the relevant work should have already been resolved at the tendering process. Now we have the tender document. The contractor is at the stage of bidding for the tender. By looking at the scope of the work, planning for the relevant work, the contractor needs to be vigilant and check for any issue with the royalties and intellectual properties. If there is no issue on the royalties and intellectual properties, the contract sum will be equals to the cost of the work, and therefore the case closed here. Let's say now we have issue with the royalties and intellectual properties. There will be royalty fees to be incorporated, and now the contract sum here should theoretically be the cost of the work plus the royalty fees, and this should have already been resolved during the tendering process. In the case that the contractor did not put into this, theoretically contractor will have to bear the cost of the royalty fee. If the contractor chooses to ignore this, not willing to pay for that, the consequences, it will be the cost for the infringement will have to be fully paid by the contractor. As implied in the statement here, the employer has the right not to undertake the cost for the royalties and the IP, and as a result, everything it will be on the contractors. This is about the flaw when the responsibility is fully due to the contractor. There are also cases that the employer is the cause of the infringement of the royalties or intellectual properties. This leads us to these sections of the flowchart. Under that circumstances, the setting it will be the royalty fee has not been incorporated. Upon knowing that, the contractor will need to notify the architect in written about the potential infringements of any parts of the works or system or material that may potentially violate the royalties or intellectual properties. Now we wait for the response from the architect side representing the employer. Let's say now the architect instruct to incorporate the royalty fees. That means the contract sum will be the cost of the work plus the royalty fee, and the case is closed. Let's say it has been made clear that they do not wish to pay for the royalties. That means there will be risk for the employer to be penalty or charged due to violations of the royalties and intellectual properties, which at the end of the day, the relevant costs may be charged by the employer onto the contractor, as implied by this clause here. With that, the contractor will need to add in the cost for the infringement, and now the contract sum, it will be the cost of the work plus the cost of the infringement. What you see from the entire picture here, when things involve the royalties and intellectual property, the relevant fees or royalties needs to be paid by hook or by crook. If it is not paid, there will be cost of infringement. That means the employer may be penalty for violating the royalties and intellectual properties. The contractor will need to be vigilant regarding this matter. The relevant costs for the royalty fees needs to be included during the tendering stage. Once the contract sum has confirmed, the employers have the right not to provide additional payment just for the royalties. Let's say now the contractor did not have those incorporated and not willing to pay. In the case, the cost of infringements penalty onto the employer has the right to claim from the contractor. This is about the responsibility of the contractor. Knowing these royalty issues, the contractor will need to inform to the architect representing the employer side to have those royalty fees to be incorporated in the contract sum. If it is being agreed, there should be no issue. The royalty fee will be paid. If the employer do not agree to pay for the royalty fees, the contractor will have to add in the potential cost of infringement into the contract sum. It is to prevent that eventually the employer charged to the contractor upon being penalized, getting the penalties due to the royalties and intellectual properties.